Okay, time to talk about how do you know, right from a fact pattern, that you're being tested on the issue of standing. Again, recall, standing is one of the issues that falls under this umbrella called justiciability, right? So if the call of the question is, should a court hear this case or entertain this case, when it comes to standing, it could be a little more specific. The question could be, does this party, right, is this party a suitable party, right, to be filing the case? But anytime you see a broader question, should a court hear this case, you should consider the issue of standing, right? Because that call to question signals that standing might be an issue, along with political question, mootness, ripeness, and 11th Amendment, right, problems. Once the call to question, right, has tweaked your interest, right, that maybe I'm being tested on standing here, what facts in the fact pattern would confirm that you're being tested on standing? And I'm going to talk about 4 categories of cases where you have to watch out for what's going on. First, watch out for any fact pattern where the facts suggest that the plaintiff's problem is that his or her feelings have been hurt, okay? Hurt feelings is the quintessence of what is not an injury in fact, right, under standing doctrine. Stigmatic harm, right, I was made to feel a certain way. Courts typically do not recognize as an injury for the sake of establishing standing in a federal court. So, any type of, in my exams, you see a name like Citizens Aghast or Citizens, citizens who want a better, government or something like that. You got to look and see, okay, so how was this group, or how was anybody in this group injured, right? How was anybody either individually or as a group injured, right, by the law? If the best you've got is whatever the government did really irked us, really made us upset, really angered us, right? That's just not going to cut it for standing purposes. So be aware of that. I call it hurt feelings, right? Just to kind of, to make this something accessible and understandable that you're looking for, right? Look in the fact pattern for any indication that that is the injury. The second category of case that would cue you that you're being tested on standing and possibly a related doctrine is when you see the facts that indicate that the plaintiff or plaintiffs, they're scared that something bad is going to happen. Watch out for that, right? And of course, the facts in the fact pattern will be specific, but I'm characterizing here, right? The facts indicate that the plaintiffs think that something bad might happen to them. That is a classic standing fact pattern, right? That is also related to the issue of ripeness, right? One of the principles understanding, as to the first element of standing, injury in fact, is that the injury has to be concrete and palpable, cannot be speculative, hypothetical, or conjectural. All that's pretty fancy language for you're afraid something bad's going to happen, but nothing bad has happened yet, right? Remember, under those circumstances, that you at least have to have an imminent threat of a concrete injury happening, right? At least theoretically, right, before a court will find that you have standing. Obviously, that idea of injury in fact is closely related to ripeness, because the definition of injury in fact is an injury that's not hypothetical, conjectural, right? And a ripeness problem means that any harm is hypothetical, right, and conjectural. It hasn't happened yet. Okay, now the next category of case, generally speaking, is not a problem unless you see a wrinkle thrown into it, right? So we're not supposed to be hearing cases as federal courts, right, where the case is not ripe, where there has been no injury yet. So obviously that means you're looking for an injury that's already happened. So typically there's no problem with a fact pattern that says, the plaintiffs are mad about something that has already happened, right? Here's the twist that would throw this off and make it into a good standing problem. If the plaintiffs are mad about something that's already happened and they're asking for injunctive relief, there is your cue, right, that you are being tested on standing doctrine. Because if you're mad about something that's already happened and you're asking for injunctive relief, first of all, you have a mootness problem as to the injury that's already happened. The court can't enjoin something that's already happened. And second of all, as to any future cases, if you can't show that the injury is likely to recur, right, or at least plausibly, right, might occur with regard to your own client or clients, then you don't have standing. Now, keep in mind there's an exception to that. issues like abortion and voting, where those issues are quote unquote capable of repetition yet evading review, right? A court might disregard this rule, but again, this is just issue spotting wise. Watch out for somebody who says, right, I'm mad about something that already happened and I want injunctive relief. I hope you get that, right? If that's the case, as to what already happened, I can't issue an injunction because it's moot, right? I.e. it's not redressable. And as to any future harm, if there's no showing on the record of a likelihood of recurrence, then that, again, you don't have a concrete injury, or at least an imminent likelihood, right, or threat of an injury. Finally is kind of an easy one to spot, and that is if you see a taxpayer in a constitutional law fact pattern, right? In some of these videos I say it's inconceivable that, what else would I be talking about or testing you on? And here's one of those, right? If you see the word taxpayer in a common law fact pattern, you are almost certainly being tested on standing. And that's because of the rule that a taxpayer, simply as a taxpayer, generally has no standing, right? There are some magic words here you want to throw around. Generalized grievance, right? As a taxpayer, the only injury we have from what the government is doing, whatever we're objecting to, whatever injury we have would be an injury that we share in common with everybody else who pays taxes, right? So that's called a generalized grievance rather than a particularized, individualized grievance, right? That would give rise to standing on behalf of a particular litigant. So if you see taxpayer in a fact pattern, watch out for the standing issue. You also need to be aware, right, of the only exception, right, to the general prohibition against taxpayer standing. And that is when an individual sues challenging a congressional spending measure. So this is right, Congress spending on religion. So basically, those are three elements, right, that trigger this very narrow exception, right? If you're challenging Congress, and Congress's spending power, right, and the Congress has spent money to promote or encourage religion somehow, if that's your allegation. In some limited circumstances, a court will say that you have standing to sue as a taxpayer. But that's very limited. So again, in terms of the categories you're looking for to indicate that you're being tested on standing, indication in the fact pattern that the plaintiff has hurt feelings, indication in the fact pattern that plaintiff or plaintiffs, right, are scared something bad might happen. That's the second one. Third, mad about something that already happened and asking for an injunction. And finally, you see any reference in a common law fact pattern to a taxpayer. Under any of those circumstances, you're probably being tested on standing. So I hope that helps with that issue, and we'll keep on going here. But that's enough for this video. Be well and stay tuned.